Did medieval women really have no say over their lives? Were they mere pawns with no claim to anything they owned? Prepare to peel back the layers of misconception about women and property in the Middle Ages, roughly from the 5th to the 15th century. Number 1, medieval women had no legal standing to defend their property in court. The echoes of medieval courtrooms often reveal voices that might surprise a modern ear. Records from across Europe indicate that women, whether single, widowed, or even married under certain circumstances, frequently engaged with the justice system to protect their interests in property. They were not silent bystanders, passively awaiting the outcomes of legal battles fought by men. Instead, they actively participated, sometimes as plaintiffs, sometimes as defendants, and sometimes as witnesses. In England, the royal courts heard countless cases where women sought justice for land disputes or breaches of contract related to property. A widow named Alice, living in the county of Wiltshire during the 13th century, is one example. Her husband had died, and his brother attempted to claim a piece of land that Alice insisted was part of her rightful dower, the portion of her deceased husband's estate she was entitled to for her lifetime. Alice did not simply accept this challenge. She appeared before the royal justices, presented her case, and cited the customs and laws that supported her claim. The court rolls of the time document her tenacious pursuit of justice, showing her arguments, the evidence she presented, and ultimately, the judgment that affirmed her rights to the land. Her case was not an isolated incident. Similar disputes involving dower lands fill the pages of court records from that era. Further north, in the towns of medieval Scotland, burgess rolls and court records also demonstrate women's legal engagement. Take, for instance, a woman named Mariota, a merchant in Aberdeen in the 14th century. Mariota had acquired a plot of land and a house within the burg. A neighbor, she claimed, had encroached upon her property line. Mariota brought a formal complaint to the burg court. The court meticulously recorded the proceedings, including Mariota's sworn testimony, the testimonies of witnesses, and the subsequent measurement of the property by town officials. This process highlights a legal system that, at a local level, recognized a woman's right to seek redress for property infringements. Mariota's case, like many others, concluded with a ruling that either upheld or denied her claim, but crucially, it shows her as an active participant in the legal process. In France, regional customs often governed property rights, and these customs frequently acknowledged women's legal standing. The cartularies of monastic institutions, which are collections of legal documents, frequently contain records of women appearing before ecclesiastical or secular courts to resolve property issues. For example, a woman called Eleanor, in 12th century Anjou, held land that she had inherited from her father. When a local lord attempted to seize a portion of her inheritance, Eleanor did not hesitate to bring the matter before the court of the Duke of Anjou. The charters of the ducal court reveal the details of her suit, outlining how she presented her familial claim and defended her ancestral lands. Such records demonstrate a legal framework that allowed women to actively protect their landed interests against powerful figures. Even within the context of marriage, where the legal concept of coverture often meant a married woman's legal identity was subsumed by her husband's, there were nuances and exceptions that allowed women a degree of legal action. While a married woman usually needed her husband's consent or had to act through him in legal matters, specific situations permitted her independent action. For instance, if a husband deserted his wife or if he was imprisoned, records show that wives sometimes gained temporary legal autonomy known as femme sole status for trade, allowing them to engage in legal transactions, including property disputes, without their husband's direct involvement. Court records from London in the 14th century occasionally mention wives suing or being sued in their own right, especially if they were trading independently or if the dispute concerned property that was specifically designated as their separate estate. Wills and testaments also serve as a rich source of information revealing women's legal agency. When a woman made a will, particularly a widow or a single woman, she was exercising a significant legal right to dispose of her property as she saw fit. These documents were often recorded in court or by legal officials, demonstrating the legal recognition of her decisions. A will written by a Parisian widow, Jeanne, in the 15th century meticulously details her bequests of houses, vineyards, and personal goods to her children and various charitable institutions. The formal legal process of drafting and registering this will highlight her undisputed legal capacity to determine the fate of her substantial property. Furthermore, women frequently acted as executors of wills, a role that required considerable legal interaction. As executors, they were responsible for managing the deceased's estate, paying debts, collecting dues, and distributing bequests according to the will. This involved engaging with courts, negotiating with creditors, and ensuring that all legal procedures were followed. The records of probate courts across medieval Europe are replete with examples of women, often widows, undertaking these complex and legally demanding tasks. A woman named Philippa, acting as the executrix for her husband's estate in 15th century Florence, oversaw the sale of a considerable amount of property to settle debts and provide for her children. The Florentine archives contain her detailed accounts and the legal documents approving her transactions, showcasing her active and legally recognized role in property management. The legal landscape of medieval Europe was indeed complex, with variations depending on region, social status, and specific customs. However, the consistent appearance of women in court records, their active participation in property disputes, and their recognized roles in wills and estate management challenged the idea that they possessed no legal standing regarding their property. These historical documents paint a picture of women who understood their rights, asserted them, and were frequently supported by the legal systems of their time. They were not always victorious, but their ability to bring a case, defend themselves, and engage in the legal process was a fundamental aspect of their relationship with property. Number 2, medieval women could not buy, sell, or manage businesses. The marketplace and workshop of medieval Europe were far from exclusively male domains. Historical records reveal that women were deeply embedded in the economic fabric of their communities, often as independent entrepreneurs, skilled craftswomen, and active managers of various enterprises. Their participation in trade, production, and services was not an exception but a common feature of daily life, particularly for single women and widows. In urban centers, women regularly operated shops and stalls, buying and selling a wide array of goods. Records from medieval London, for example, show women engaging in the sale of foodstuffs like bread, ale, and fish, often working as independent vendors in the city's bustling markets. A woman named Christine in the 14th century ran a successful bakery in Cheapside. She purchased flour, managed her production, sold her loaves, and handled her own accounts. The city's customs allowed her as a femme sole, or single woman, to conduct business entirely independently, entering into contracts and pursuing debts in her own name. This legal status, often granted to single women or married women specifically for trade, allowed them to act as independent economic agents. The brewing industry, a vital part of the medieval economy, was heavily dominated by women for centuries. The women, known as brewsters or ale wives, produced ale for their households and for sale. In many towns and villages across England, France, and Germany, brewsters were numerous and central to local economies. The records from towns like York and Norwich frequently list women paying taxes on their brewing operations, indicating their recognized status as producers and sellers. A brewster named Matilda, in 13th century York, not only brewed and sold ale, but also managed her own malt supply and distribution network. The records show her buying ingredients, hiring laborers, and dealing with customers, all as an independent business owner. Textile production was another area where women's economic contributions were immense. From spinning and weaving to dyeing and selling finished cloth, women were involved at every stage. In Florence, a leading textile center, women worked in workshops and as independent weavers, often owning their looms and tools. Some women even managed small textile businesses, employing others. Documents from Flemish towns, renowned for their cloth industry, show women as master weavers or as owners of workshops, overseeing production and trade. These women handled apprentices, managed raw materials, and navigated the complex market for textiles. Beyond specific crafts, women also managed inns, taverns, and lodging houses. These establishments were often family businesses, but it was common for wives or widows to take primary responsibility for their management. They handled reservations, oversaw staff, managed supplies, and dealt with guests. A widow named Agnes in 15th century Paris successfully ran a popular inn near the city gates. Her property records show her acquiring additional rooms, hiring staff, and managing all aspects of the business. Her enterprise was substantial enough to be listed in urban tax records, indicating its significant economic contribution. Women also engaged in money lending and pawnbroking. Though sometimes seen as controversial, these activities were often vital services in medieval communities, providing access to credit. Records from German cities like Frankfurt document Jewish women engaging in large-scale lending operations, demonstrating their financial acumen and business independence. Christian women, particularly widows, also engaged in smaller-scale lending, often securing their loans against property or goods. These transactions required a sophisticated understanding of finance and risk. In rural areas, women were often integral to the management of farms and agricultural estates. While men typically handled fieldwork, women were responsible for managing the dairy, poultry, gardens, and often the storage and sale of produce. A landholding widow in medieval England might directly oversee the entire operation of her manor, negotiating with tenants, managing laborers, and directing agricultural output. Her manor court roles often detail these women's involvement in economic decisions, from renting out lands to collecting rents and managing finances. For example, Lady Joan, who held the manor of Chetwynd in the 14th century, after her husband's death, personally directed its agricultural production and financial affairs, as evidenced by detailed manorial accounts from her period of management. Guilds, which regulated many trades in medieval towns, sometimes excluded women from master status. However, many guilds allowed women to be members, especially if they were widows who inherited their husband's guild membership and business. In some cases, women even formed their own guilds, such as the Silk Women's Guilds in Paris, which flourished from the 13th century onward. These guilds were entirely composed of and run by women producing luxury silk goods. The maitresses lingers or linen draper women of Paris formed a guild that regulated the trade of linen and textiles, demonstrating collective female agency in business management and regulation. The notion that medieval women were confined solely to the domestic sphere and lacked the capacity for independent economic activity is consistently challenged by the abundance of historical evidence. From small-scale vendors to managers of significant enterprises, and from skilled craftswomen to moneylenders, women were active, vital, and recognized participants in the medieval economy, often exercising considerable autonomy in their business affairs. Number 3. A married woman's property automatically became her husband's property, no exceptions. The legal principle of coverture, prevalent in many parts of medieval Europe, particularly in England, certainly gave husbands significant control over their wives' property. Under this system, a married woman's legal identity was largely subsumed by her husband's bearer. She could not, in theory, make contracts, own property, or sue in her own name without her husband's consent. However, this legal theory did not always translate into absolute practical control, and there were indeed important exceptions, customs, and arrangements that allowed married women to retain or control certain assets. One of the most significant exceptions was the concept of dower. This was not property that a wife brought into the marriage, but rather a provision for her after her husband's death. Customarily, a widow was entitled to the use of 1/3 of her deceased husband's land for the remainder of her life. This dower land was hers to control and derive income from, and her husband could not alienate it or dispose of it without her consent during his lifetime. Upon her husband's death, this portion became her legal right, providing her with financial independence and status. For instance, after the death of Sir John in 14th century England, his widow, Lady Eleanor, took immediate possession of the stipulated third of his extensive estates. She managed these lands, collected rents, and controlled the agricultural output, acting as an independent landowner, as evidenced by manorial court rolls and financial accounts from her period of widowhood. Another common arrangement was the jointure. This was a settlement of property made to a woman in contemplation of her marriage, which would be hers for life if she survived her husband, in lieu of dower. Unlike dower, which was a customary right, jointure was often arranged through a formal agreement or marriage settlement before the wedding. This allowed for more flexibility in specifying what property a woman would control. For example, a marriage contract from 15th century France might specify that a bride, upon her marriage to a nobleman, would be granted a specific manor and its revenues as her jointure. This arrangement ensured her financial security and a degree of control over property even after her husband's death, and crucially, it was agreed upon before the marriage, often protecting assets from being fully absorbed into the husband's estate. Separate estates or trusts were also employed, particularly among the wealthy. These arrangements allowed property to be held to the wife's separate use by a trustee, preventing the husband from having full control over it. While the legal complexity varied, these trusts were designed to protect a wife's inheritance or dowry from her husband's debts, mismanagement, or even alienation. An example might be a rich merchant's daughter, whose dowry, instead of being given directly to her husband, was placed in the hands of her male relatives or legal guardians who administered it for her benefit. This allowed her to receive income from these assets or have them available for her use without them becoming her husband's property. Legal documents show these intricate settlements being drafted to secure a woman's financial independence even within marriage. Furthermore, a wife's paraphernalia, her clothing, jewels, and personal ornaments, was generally considered her separate property and did not fall under the husband's control. While perhaps not as significant as land, this category often included valuable items and represented a degree of personal ownership that remained with the wife throughout the marriage. The wills from the period frequently list specific items of jewelry or clothing bequeathed by women, indicating their personal ownership and right to dispose of these goods. Dowry, the property a wife brought into the marriage, often became the husband's property to manage and use. However, even here, there were complexities. In some regions, especially in Italy and parts of France, the dowry was legally distinct from the husband's property and was considered a fund for the wife's support during marriage and her family's support after his death.
If the husband died, the dowry was typically returned to the widow or her family.
If a marriage ended, particularly through annulment, efforts would be made to ensure the dowry was returned to the wife or her family. The detailed records of Florentine dowries, for instance, show careful accounting of these assets and the legal obligation to return them if the marriage dissolved. Local customs and urban charters also provided exceptions to the strict application of coverture. In many towns, women who engaged in trade independently, known as femme sole, single woman for the purpose of trade, were allowed to enter into contracts and incur debts in their own name, separate from their husbands. This status was typically granted to wives of merchants or craftspeople who conducted their own businesses. For example, a wife running a shop while her husband was away on business would be legally recognized as acting on her own behalf in commercial dealings. This allowed married women to manage their own business assets, buy stock, and deal with customers without their husband's constant legal involvement, even though they were still married. The property relations between married couples in medieval Europe were therefore far more nuanced than a simple transfer of all assets to the husband. While the husband was generally the head of the household and controlled most joint property, the existence of dower, jointure, separate estates, and customary exemptions for trade demonstrate that married women retained various forms of property interests and control, safeguarding their financial security and sometimes allowing them independent economic agency even within the bonds of marriage. Number 4, medieval women could not inherit land. The idea that medieval women were entirely excluded from inheriting land is a widespread misconception. While male primogeniture, the custom of inheritance by the eldest son, was indeed common, especially among the nobility in certain regions, it was by no means universal or absolute. Numerous circumstances allowed women to inherit and hold substantial landed property. One of the most significant ways women inherited land was when there were no male heirs. If a landowner died without sons, his daughters would typically inherit his estate, often equally among them. This practice, known as co-parsenny, meant that multiple sisters could become co-owners of a substantial inheritance. For example, when the powerful Earl of Chester died without male heirs in the 13th century, his vast estates were divided among his 4 daughters. Each daughter became a significant heiress in her own right, bringing considerable land and influence to her marriage or managing it independently if she remained single. These divisions are meticulously recorded in royal charters and legal documents of the period. Widows, as previously mentioned, frequently held land through their dower rights. A widow was entitled to a portion, usually 1/3, of her deceased husband's lands for the duration of her life. This was not a temporary allowance, but a legal right to possess, manage, and derive income from that land. Powerful noblewomen like Eleanor of Aquitaine, who held extensive lands and rights in her own name even after her marriages, illustrate how such inheritances could confer immense power and influence. Even at a lower social level, peasant widows often inherited the tenancy of their husband's landholding, or a significant portion of it, ensuring their livelihood and providing continuity for the family farm. Manorial court rolls are filled with entries detailing the transfer of land to widows upon their husbands' deaths. Beyond dower, widows could also inherit land outright if their deceased husband specified it in his will, particularly if there were no children or if he wished to ensure complete independence. The wills from the period show men leaving their wives' entire estates, houses, and revenues, sometimes with conditions for their eventual transfer to children, but often granting the widow full control for her lifetime or even in perpetuity. A wealthy merchant's widow in 15th century, Bologna for instance, inherited several houses and agricultural properties from her husband, which she then managed and eventually bequeathed to her own family, as documented in her detailed testament. Single women, including spinsters and nuns, also had full rights to inherit and hold land. If a woman never married, or if she was a nun who took vows but retained her family property, which was possible in some convents, she could inherit land from her parents or other relatives. These women had full legal capacity to manage their estates, collect rents, engage in legal disputes, and dispose of their property through wills. A particularly striking example is that of Dame Marjorie Kempe, a laywoman in 15th century England who managed properties and finances, though not necessarily landed estates, through her various business ventures, illustrating a degree of financial independence outside marital control. While she is known for her spiritual autobiography, her life also touches upon property management. Moreover, in certain regions and under specific legal customs, such as the partible inheritance systems common in parts of Germany and Scandinavia, land was divided among all children, sons and daughters alike. This meant that daughters regularly inherited shares of their parents' land alongside their brothers. For example, in many parts of Flanders, daughters were considered equally as entitled to inherit parental property as sons, leading to fragmented landholdings but ensuring that women regularly acquired landed property. Even when male primogeniture was the prevailing custom, women often inherited movable property, such as livestock, household goods, money, and valuable items. These were not insignificant, as movable wealth often underpinned the family's economic stability. A woman might not inherit the primary ancestral manor, but she could inherit valuable silver, tools, or a significant sum of money that allowed her to live independently or contribute substantially to her marriage. Her wills often specified these bequests, demonstrating their importance. Royal and noble women also frequently inherited vast territories and titles through their lineage, not just as wives or regents. Duchesses, countesses, and queens sometimes held hereditary rights to their lands, independent of their husbands or sons. For example, Constance of Sicily, a 12th century queen, inherited the kingdom of Sicily in her own right, demonstrating direct female succession to immense territories. While these were exceptional cases, due to their high status, they nonetheless underscore that female inheritance of land and sovereignty was a recognized legal possibility. The historical records, from feudal charters to peasant land registers and individual wills, present compelling evidence that medieval women were not universally barred from inheriting land. While cultural norms and legal traditions varied, women regularly acquired, managed, and controlled landed property through various channels, challenging the simplistic notion of complete male dominance in land ownership. Number 5. Medieval women had no property rights at all. The sweeping assertion that medieval women had no property rights stands in stark contrast to the rich and varied historical evidence from the period roughly covering the 5th to the 15th century. While their rights differed significantly based on social class, marital status, geographical location, and specific legal customs, women often held, managed, and controlled various forms of property. The nuances of medieval law and custom provided avenues for women to possess wealth, land, and goods in ways that often surprise modern audiences. One of the most fundamental property rights for women was the concept of the dowry. This was property, often money, goods, or land, that a bride brought to her husband upon marriage. While the husband usually gained control over the dowry for the duration of the marriage, it was generally considered the wife's property and was intended to provide for her and her family. In many European regions, particularly in parts of Italy, the dowry was legally protected and often returned to the wife or her family if the marriage ended, for example, through the husband's death or annulment. Records from medieval Florence show meticulously detailed dowry contracts specifying the goods and money a bride brought and the legal obligations for its management and potential return. A bride's dowry, even if managed by her husband, was a substantial financial asset that acknowledged her contribution to the marital estate. Beyond the dowry, the institution of dower, discussed earlier, was a crucial property right for widows. Upon her husband's death, a widow was legally entitled to a portion, typically 1/3, of her deceased husband's lands for her lifetime. This land was hers to use, manage, and derive income from, providing her with economic security and a base of operations. The Domesday Book, a comprehensive survey of England completed in 1086, lists numerous women, primarily widows, as direct landholders. For example, a woman named Judith, Countess of Huntingdon, held extensive lands in her own right as a tenant-in-chief directly from the king. Her example, though high status, demonstrates that women could indeed be significant landowners. Single women, often referred to as femsole, whether spinsters or widows, enjoyed the most extensive property rights. They could own, inherit, buy, sell, and mortgage property, enter into contracts, and pursue legal actions in their own name. They had full legal capacity, much like men. Their records from medieval towns show numerous single women running businesses, holding property, and engaging in financial transactions. For instance, the city records of London often mention spinsters or widows as property owners, taxpayers, and participants in civic life, all demonstrating their independent economic standing. A woman named Agnes, a tailor in 14th century London, is documented owning her workshop and house, managing her business, and paying taxes as a proprietor. Even within marriage, where the legal doctrine of coverture was strong, there were significant exceptions and variations. In some regions, especially in parts of northern France and Germany, community property regimes existed, where property acquired during marriage was considered jointly owned by husband and wife. This meant that the wife had a recognized share in the marital assets. While the husband typically managed the community property, his power to alienate it without his wife's consent was often limited. The marriage contracts from Normandy often outline provisions for wives to retain control over specific assets or to share in the gains of the marriage. Furthermore, a wife's paraphernalia, her personal effects like clothing, jewelry, and sometimes household items, was legally considered her own property and was not subject to the husband's control or his creditors. These items, though personal, could be quite valuable, especially among the wealthier classes, representing a significant portion of a woman's individual wealth. The wills frequently list these items, showing women bequeathing their own jewels or fine garments. The existence of trusts and marriage settlements also allowed for the protection of a woman's property from her husband's control or his debts. Wealthy families would establish these arrangements to ensure that a daughter's inheritance remained secure and under her control, even if managed by a trustee. These legal mechanisms illustrate a deliberate effort to circumvent the stricter aspects of coverture and ensure a woman's financial autonomy. Across various social strata, women were often integral to the economic life of households and communities. While a peasant woman might not own land in the same way a nobleman did, she often held traditional rights to common lands, gathered resources, and managed household production. Her labor in the fields, gardens, and in textile production was a recognized contribution to the family's wealth, and she often had customary rights to the fruits of her labor. The legal and customary landscape of medieval Europe was diverse. While the ideal of male headship and the legal theory of coverture were prominent in some places, they did not erase all forms of female property ownership and control. Instead, a complex system of dower, dowry, jointure, separate estates, and the independent rights of single and widowed women ensured that medieval women, in many instances and through various means, possessed, managed, and controlled property, directly challenging the simplistic notion of their complete dispossession.